Also understand, though, that you'll have to go into custody. That time will have to be calculated. Even if you have enough credit, then you would be released as soon as that's done. Do you understand? Yes. Also, if you don't show up on that date, then the deal's off and there'll be a warrant for your arrest and you'll be looking a lot more time. Do you understand that as well? Ma'am?
Yeah.
Did you just call me by my first name? We don't know each other, do we? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Your
And we're going to count one only, correct?
Yes.
Mr. Valentino, in cause number 25, BCCR 0120, the state's elected to proceed on count one only. Just went away. Hold on. It alleges you committed the state jail felony offense of theft of material, aluminum, bronze, copper, or brass from April 7th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
It's not.
And are you pleading guilty because you actually did what they charged you with?
It's
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've reached with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for an 18-month term. Oh, y'all put county jail. That's state jail, right?
It's state jail. Yes,
That's right. In the state jail prison. And you would receive credit from the date of that arrest. We've talked already on the record that you were in custody in TDC from the time of this arrest. You were immediately transferred to TDC on another case, correct?
Yes, ma'am.
And the clerk has done the calculation, and it looks like that would be 600. Is that a
55, yes, ma'am.
655 days that you would receive on your sentence. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Valentino is not competent?
No, Your Honor.
And so, Mr. Valentino, it's my understanding that we're talking with your attorney, that you need just a short amount of time so that you can go into custody. You weren't prepared for that today. What I'm willing to do is reset your case for sentencing till next week on Monday, and then you can come back and we'll sentence you on that date. Yes, sir.
Judge, and speaking with Mr. Valentino, as you know, he was recently released from prison. He was able to find a job. He is working now, taking care of a sick mother. He was asking if we can get 30 days just to make sure that stuff he doesn't lose all that stuff when he, because he's going to have to go into custody. He'll be away for some amount of time after he does come back and get sentenced.
I'm not going to do 30 days. I think I understand that you've been in custody, but you also have some criminal history that gives me some concern. The most I'm willing to do is 2 weeks. Ms. Malfino, any issue with that? All right, so I'm going to reset your case for 2 weeks. Now, there's some very important things about that, which a couple of things. Number 1, obviously, if you're arrested for anything between now and when you come back, I'm not going to accept this plea agreement. Things could be much worse. With your criminal history, this could be a TDC case. You could end up with more than 2, obviously more than 18 months in the state jail. Also, if you don't show up on that date, then the deal's off and there'll be a warrant for your arrest and you'll be looking a lot more time. Do you understand that as well?
Yes.
Right. State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Valentino is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent. Did I already say all this? It's been a long day.
Thank you.
I did, didn't I? I thought so. Started sounding familiar. All right, so what I'm going to do then is reset your case again. We don't need a pre-sentence report, and we'll just come back for sentencing in 2 weeks. All right? Okay, see you back then.
Thank you, Judge.
I started saying that. I was like, wait a minute, because I get sidetracked saying any though. No paperwork on that. Good morning, sir. Are you Joshua Barlow? And this is a motion to revoke probation. It looks like Mr. Barlow is on probation for possession of a controlled substance, penalty group 1. What is the announcement?
Judge, Mr. Barlow did retain me to represent him over in Harris County in regards to the new law violation, and actually also partially the technicals. As part of that was about living or being in Harris County during that time of the offense. We were in court Thursday. There is a 911 recording that we will have probably either today or tomorrow. That is going to say a lot for us about whether they're going to proceed with the case over there. And also, honestly, if they're going to file new charges against the complainant. As well as, I think that will also give us a lot of insight into the technical violation of his residence at the time because of the information that would have been given to transfer over the video. So I'm just asking for a short time so we can listen to that.
And as far as everything going okay right now on probation? Okay. All right. So we'll just do a normal reset so you can get all that information, get it to Ms. Malfino, and then we'll see where we are on that next court date.
Judge, in light of the violation alleged in count 6, which is the positive UA on March 4th of 25 and April 8th of 25 for marijuana, he does not currently have a drug patch. I'm assuming from Officer Kitchens that he has no UA violations during the pendency.
I gave him a drug test 310 this month, anticipating this court appearance, and he tested negative.
Okay. Obviously, if there's any issues, just let me know, or we can get that drug patch ordered real quickly if we need to. All right.
Judge, also, Mr. Barlow did let me know that he does have he sent me with confirmation. He has a job interview tomorrow at 10:30.
Okay.
So we just wanted to make sure you all have that because he is, of course, on restrictions with the GPS monitoring.
Okay, just send that over in a memo if you would, so that I know, make sure you talk to probation so they know where you're going as well. Okay? All right, thank you. Corey Richardson, Mr. Crenshaw. All right, sir, you're Corey Richardson. And will your client waive the formal reading of the indictment?
We do, Your Honor.
Mr. Richardson, in cause number 25, DCCR 0249, the state has elected to proceed on the lesser included offense of a Class A misdemeanor attempted solicitation of prostitution from November 21st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you've done what they charged you with? Speak up.
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Crenshaw?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Then it looks like the agreement is for a 2-year deferred probation. Is there a fine?
I believe there is a $500 fine.
I mean, it's up to the court, but I would think there would need to be a fine. If y'all want to agree to something, that's fine. If not, I would impose $500 for sure.
500's fine, Judge.
So there would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding of your agreement?
Yes.
And are you a U.S. citizen?
Yes.
State tenders number 1.
Yes, Your Honor.
No, Judge.
It's admitted. Is there any evidence that Mr. Richardson is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily to the lesser offense of Class A misdemeanor attempted solicitation of prostitution. Find that you entered that plea freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement and defer all proceedings for a period of 2 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do all of that, this is an excellent opportunity because you don't have the conviction on your record. And at the end of the probation, if you're successful, the case would be dismissed. You'll never have the conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and be sent to the Jefferson County Jail for 1 year. Do you understand?
Listen,
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. She's at that desk right over there, so watch for her to put it in. Okay? Good luck to you, sir. Thank you.
Thank you, Judge. Thank you, Miss.
You're welcome. Last one.
I think that's every active case I have on your file.
Well, you need to get some more.
Yeah. To go back to work. Thank you all. Have a great day. It's stayed forward at 8:15 this morning. She's giving me an announcement. She can't get it, but you'll have it.
Mr. Lewis on Janisha Jackson.
yeah,
Right, ma'am, you're Janisha Jackson?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
she does.
So did we start something and then not do it? Last on the 2nd? Were we here March 2nd? I show that I have a revised indictment already.
I don't recall that.
Okay. See, I made a note on it. Oh, we must have been, that's when I made the change to the heading.
Yes.
Okay. So, Ms. Jackson, in cause number 25 DCCR 0903, you're charged with the state jail felony offense of abandoning or endangering a child from May 26th of 2025. And how do you plead to that charge?
Guilty?
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you
Yes,
with?
ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. And also there's part of the agreement is that you would not request early termination from probation. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No, objection.
It's admitted. Is there any evidence that Ms. Jackson is not competent?
No,
Right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea.
Yes.
Find sufficient evidence to find you guilty. However, I'm going to reset your case. I'd like to get a pre-sentence report on it. That'll just give me more information about you and your case, and we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to probation. She's sitting at that desk right over there.
Yes.
And then we'll see you back at sentencing. Okay. All right. Thank you. Thank
Thanks,
you,
Judge.
Lewis. Mr. Let's see. Brittany, do you have something else? No. Okay. Candy, Baraka. Good morning, ma'am. You're Candy Baraka.
Yes, Your Honor.
And Ms. Baraka, you had filed a petition for expunction. Sorry.
Go ahead. It's okay.
You had filed a petition for expunction in 2 cases.
Yes.
One was M241026, which was a failure to identify And then the other was 23 CCCR 2497, which was a theft of property case. We called your case earlier but
Sorry,
when
Your
we
Honor,
came,
I flew in from Los Angeles.
I'm sorry.
I flew in from Los Angeles.
Okay.
I was in the hallway. Sorry.
So the state's position, and I already made an order in your case,
Yeah.
and also the city of Beaumont was here as well, with the opposition. And the opposition by both of them is to the failure to identify case, which is, hold on, don't talk over me, which is M241026. They did not have opposition in the theft of property case. I have agreed and ordered the expunction in the theft case. However, because you pled guilty or no contest in the failure to identify case and received a probation, you're not eligible for an expunction in that case. If it was a deferred probation, you may have some rights to what's called a non-disclosure. If you finish a deferred probation, as long as there's not conviction. So you'll have to check into that. But, and it's not quite as good, I guess, as an expunction, but it is something if it was a deferred probation and if you satisfactorily completed it. So you can look into a non-disclosure for that one.
Okay.
But I did sign it, or I am going to sign the order for the theft, but not the other one.
I'm fine. I just thought that because it was maybe, I think 20 years ago.
Yeah,
It was
unfortunately, the age doesn't
I'm
matter.
glad you told me how I can go about it.
Yeah, they're required by law to check everyone that comes through, and if you're not eligible, you're not eligible.
Okay.
But you can look at that non-disclosure for the failure to.
And I appreciate you, Raquel.
Yes,
Have a
ma'am.
blessed day.
Ma'am,
Your Honor.
you just call me by my first name.
Judge.
We don't know each other, do we?
Fine. No, man. But I
Okay.
do appreciate you. Thank you.
Okay, you're free to go.
Have a blessed day. Okay.
Yes.
No, if I've had the first name. We go way back, 3 minutes. Oh, that's okay. That's okay. Mr. Rennick, you have John Sharp.
Yes, Your Honor. No, we'll be.
Okay, give me, I'll call it as soon as that's all ready.
You can call me that first thing.
And I wouldn't even, we have known each other a long time and I still wouldn't give it to you in court.
Feel free.
Mr. Rojas, you have Maria Garza.
Yes, ma'am.
Okay, so we have someone on
We're going to talk to you about that also.
Okay. Good morning. Are you Maria Garza? And this is 25 DCCR 1008. Ms. Garza is charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, we're asking for at least 30-day reset so Ms. Malpino can send the victim a subpoena, see if he'll show up next time in hearing.
Okay.
That's correct, Judge. I will send a subpoena and a letter, both in English and in Spanish, based on the information received from Mr. Rojas today.
Okay.
Ready to endorse.
All right. We'll just do a normal reset to give you time to get that taken care of. And Ms. Garza, stay in touch with Mr. Rojas and your bondsman. They'll let you know when to be back. Okay. You're free to go.
Thank you so much.
And you have Whitley Shepherd.
She may have stepped out for you, but
Whitley Shepherd, if you'll call the name, please.
Willie Shepherd.
Good morning, ma'am. Are you Whitley Shepherd?
Yes, ma'am.
And Ms. Shepherd, in cause number 25 DCCR 1146, is charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, Ms. Shepherd and I have previously talked about her case early on. I just got an offer last week and I've talked with her a little bit this morning. I think I need more time to explain to her what it all entails.
Yes, sir. And so, Ms. Shepherd, I'm going to do a normal reset in about 30 days. Make sure you call and make an appointment soon to go visit with Mr. Rojas. So y'all go over everything, all the discovery, what your options are, things like that. And then we'll get an announcement at the next court date, okay? Answer out loud, please. Thank you. You're free to go.
Hand out your pocketbook.
Good morning, sir. Are you John Sharp?
Yes, ma'am.
Judge, with the court's permission, we're going to proceed on a lesser included Class A terroristic threat public service.
Yes, ma'am. Will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Sharp, in cause number 25, DCCR 1476, the state has elected to proceed on the lesser included offense of a Class A misdemeanor terroristic threat. And that's from September 6th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rennick?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. Sharp is not competent?
There is not, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years.
Yes.
You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that and do your successfully complete your probation, then this is a great opportunity because you don't have the conviction on your record. And at the end of the probation, if you're successful, the case is dismissed. You'll never have the conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be facing, number 1, the conviction, and 2, a sentence in our county jail for up to 1 year. Do you understand? I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation, she's sitting at that desk right over there. She's going to call you up when she's ready to go over your paperwork.
Yes, ma'am.
All right. Good luck to you, sir.
And Judge, I failed to bring the certificate for discovery up, so I'm going to bring that right up.
Okay, if you'll go ahead and get the one
Yeah,
signed,
right.
please, and then just have email the attachment to Ms. Holmes, please. Yeah, we did.
Yeah, regardless of any consent or lack thereof, or the validity of a subsequent K-9 alert or lack thereof, this defendant was going to be arrested, the vehicle was going to be inventoried, and that cash that was inside that vehicle was going to be seized for further investigation as to whether or not it was proceeds of illegal activity.
That's correct.
I have more questions, Judge, but I don't know if that.
Do you have any questions of the witness with regard to the suppression issue? And then you can do that, and then I'll make that determination, and then Mr. Coleman can continue.
I do have a couple questions.
Go ahead.
Real quick, you had stated that the vehicle's inspection sticker, the registration sticker is expired 2023.
Can I look at my notes? The exact name?
Yes, sir.
Was, what was the date you said? I'm sorry.
Will you tell me what was the date that it was last registered, or what date did it become expired?
That expired in March of 2023. And that was through the check through the MDT computer.
Do you know who owned it in 2023 when it became expired?
I didn't document it in my report, but I know it was on the MDT.
Okay. Do you know whether it was Ronnie Green or not?
It was not Ronnie Green. As a matter of fact, we had a conversation about it going to a Hispanic guy to Houston, Texas.
Okay. So, and you were able to verify that it belonged to a Hispanic guy in Houston, Texas?
We weren't able to verify because he no longer had that person's point of contact, cell phone number, and he advised he bought it from Facebook Marketplace, and he was unable to get hold of the owner.
Okay. But you had access to records internally through the police department, right?
Right, but I don't think we keep records of phone numbers for subjects in Houston. I don't think it's going to document in RMS.
Sure. But I guess my question is, did you verify the name of the owner?
Verify the name of the owner?
Yeah, I mean, what did your system say who owned it in 2023?
Without that information from me, I would have to go back and run the plate again.
But it wasn't Ronnie Green.
It wasn't Ronnie Green.
Was it the person's name that he gave you?
I'm not sure. I would have to watch the video again.
Okay. What about in 2025 when this stop was made? Did you look up to see who owned the vehicle at the time that you made the stop?
Yes, the MDT computer. Yes.
Okay. Did the computer say that Ronnie Green owned the vehicle?
No.
Okay. Who did it say owned the vehicle?
You're asking a question that I can't remember. I'd have to go back and pull up the MDT computer or the video to watch it.
We may be able to answer that after we watch the video, right?
But possibly.
Okay. But to be clear, in 2025, when you stopped Mr. Green in that vehicle, he was not the registered owner.
That's correct.
Okay. At any time since then, have you looked up to see at any time has the registration of that vehicle changed?
Yes, so he had the title in the glove box that had 3 owners, but none of them were ever switched over to each owner.
Okay. Let me ask you that then. So he had in the vehicle, he had a title.
That's correct.
And it was to that vehicle.
That's correct.
Did you ever look to see if any of the names of owners on that title matched the name that the vehicle was owned by in your system?
I'd have to go back and watch the video. But none of the names on that title had Green on it.
I understand that. But did any of the names match who you believe to be the true owner according to your internal system that you're allowed to use?
So we'd have to go back and watch the video.
I think that tag that you believe was fictitious, or that was fictitious, you don't know who put that tag on the vehicle, do you?
That's correct.
You don't know how long it's been on the vehicle.
That's correct.
The reason why you arrested Mr. Green for that violation at some point was because he was the driver of the vehicle. Is that correct? Not because you had knowledge that he had placed the tag on the vehicle.
He was operating a vehicle that had a fictitious license plate on it.
Okay. Do you know what the correct mens rea is for that offense?
Judge, I would object to the legal question outside of the
Assistant.
expertise of this witness.
Did you ask Mr. Green if he put that tag on the vehicle?
Let me reflect my notes. Let me see where we're at. Yeah, I put my report. I didn't put it in there.
Sorry?
We'd have to watch the video. I'm not sure because I didn't put that in my report.
So you don't know if you even asked Mr. Green if he put the tag on there?
I'm not even sure. I'd have to go back.
Did Mr. Green ever tell you anything about the tag?
The only thing that he said that he purchased the vehicle from Facebook Marketplace. He was unable to get a hold of the previous owner to change the title. And then the title showed that it had 3 different owners from the city of Houston. He also advised that he actually advised he purchased the vehicle from a Hispanic guy in a different city, but didn't know how to get in contact with him.
Yeah. Since the arrest of this case, have you done any investigation as to who owns the vehicle or if the vehicle ownership has changed?
No, sir.
Not at all.
No, sir.
Isn't it common that when you buy a used vehicle that it will have a paper plate?
We have a temporary tag.
Temporary tag.
All right, those changed.
Isn't that basically what was on the vehicle, some kind of temporary tag?
I mean, there was just like it looked like it was photocopied, laminated, and the barcode didn't scan to nothing. They're supposed to be able to come back to what the vehicle is registered to the owner.
But it was a paper plate, right?
It was laminated. It was a Xerox copy paper plate that was laminated.
Was it metal?
No,
It wasn't consistent with a permanent plate.
right, that's correct.
It's more consistent with like a temporary plate that you would receive when you buy a new or used vehicle.
That's correct.
And Mr. Green told you he had just bought it used, correct?
About 3 months prior to this stop.
Why did you ask for consent to search the vehicle?
So I knew I was going to arrest him regardless for that offense. As a matter of fact, he had contacted his mother. I think he requested to release the vehicle to his mother. I said no, because policy, since we had the total vehicle, especially if we're going to conduct an inventory in the vehicle, suspect vehicle. And the reason why I did that, if you watch video on scene, I contacted the district attorney's office and spoke to two DA, defense attorney or prosecutors to let them know what I have. And I was instructed to get further additional evidence on top of whatever you have in reference to the money so we can actually investigate money laundering at that point. So regardless, I'm still going to go to that vehicle, still take that money and conduct a further investigation for the money laundering, which I later filed that case.
Okay. So my question was though, is at the time, whenever you saw the money, you got him out of the vehicle, why did you ask for him consent to search his car?
To get additional evidence for the money laundering, because for a future case that I was going to investigate. That's the case.
So let me make sure I understand right, okay? So you got him out of the vehicle. You decided you were going to arrest him right then. But before you acted on that, you called the district attorney's office.
Well, I explained to him, I asked for a consent search. I explained to him, he asked me why.
Hold on. I want to make sure we get in the right order of events here.
We're going to go back. I'm laying out to you exactly where I got him out of the vehicle for safety reasons. So I'm not, at this point, don't know if there's any weapons in the vehicle or anything can harm us. And we want to further investigate the real life play lights. We got him out of the vehicle. He asked me, I asked for consent. He asked me what for. I said, hey, I have reasonable suspicion that there's possibly narcotics in this vehicle. And I laid out to him, I know you're on felony probation. I know him before. We have a previous encounter with each other. I know you left a no narcotics location. And this is the reason why I'm contacting K9.
Okay. Pause that thought. You just gave several reasons why you believe you had reasonable suspicion at that point in time, correct?
That's correct.
Okay, reasonable suspicion gives you the right to detain someone, right?
That's correct.
And you then, because of that reasonable suspicion you had, decided that you wanted to search his car,
For
right?
additional evidence towards the money laundering case.
Right. And so you then asked him for that permission.
That's right.
And then that permission would have allowed you then to search the car with his consent, right?
That's correct.
Okay, but he didn't give you that consent.
I didn't give my consent.
And so then you decided to go call the district attorney's office?
I want to figure out how we can further proceed to seize the money of some vehicle because I knew it's from proceeds from illegal activities.
Okay. So at that time, you believed you had reasonable suspicion?
That's correct.
Okay. But you wanted additional advice on how to handle that reasonable suspicion or what to do with it?
Additional evidence to go about the procedure of actually seizing that money.
Okay. So who'd you call?
The district attorney's office.
Okay. Well, that's you called the elected district attorney or you called?
So I talked to Raymond Shear, the intake attorney, laid it out to him. He referred me to Kathleen and civil forfeiture, and I spoke to her on the phone. And all that's on video.
Okay. The goal is to get your hands on the money.
For an additional charge of money laundering.
And so based on those conversations, was it discussed that you should just go ahead and open a door and just go ahead and get what you want out? Was that the advice you were given?
No, so I already told them that he was going to go to jail regardless, into inventory. But they suggested or strongly advised that, hey, to get additional evidence, see if the money would alert the odor of narcotics would, the K9 handler would alert on the vehicle for narcotics odor.
Okay, so let me make sure I understand. All right. You believe you have reasonable suspicion.
Mm-hmm.
District Attorney's Office says, don't just search the car, get a drug dog out. And he has not consented to a search yet.
That's correct.
Okay, so drug dog comes out,
That's
right?
correct.
You believe you had reasonable suspicion to call that dog out?
That's correct.
You know you need that, right? You need reasonable suspicion to call it
And
out.
I just explained what all the reasonable suspicion I had for narcotics being in that vehicle.
Okay. And based on that reasonable suspicion, you decide to employ a drug dog to determine if there's probable cause to search the car.
To alert on the money, to see if it has a narcotics odor.
Well, you ran the dog on the car, not the money.
Well, if the money's been around narcotics, it's gonna have to be narcotics.
Okay. First of all, you didn't handle the dog, right?
No, I don't handle them.
How's that dog been trained?
No, that officer's here and they can testify to how that dog's trained.
Do you know where that dog got certification?
I don't.
Okay, so you don't really know if it's a drug dog, right?
Well, I do. It's if they're certified to work for the city of Port Arthur for narcotics odor, I'm sure they are certified.
But you're assuming that based on the fact that a handler shows up with the dog, right?
Right. But you can ask, she's here, you can ask her.
Okay, perfect. And we will.
All right.
So the drug dog comes out and goes around the vehicle, right?
That's correct.
And then you're waiting on the handler to tell you whether the dog hit or not so that you can then search the car. Isn't that the way it works?
That's correct.
Okay. And so you're standing there and you're not participating in the drug dog searching part, right?
That's correct.
You're waiting on the handler to do their job.
To notify me that they alerted to narcotics odor response in the vehicle.
Okay. And when you receive that, that's when you then search the vehicle.
That's correct.
Okay. Which is basically the way it's always done, right?
That's correct.
Okay. In your statement, in your report on page 9, can you go to page 9? On page 9, on the second paragraph, I'm going to read that sentence to you and I want to make sure that that's accurate. It says, shortly after K-9 Officer Williams arrived on scene and conducted a free air sniff on the suspect's vehicle, right? The vehicle. And then almost immediately, Officer Williams' K-9 partner alerted to the driver's side door on the suspect's vehicle, right? So the dog hit on the vehicle, not the money.
That's correct.
Right. And then Officer Williams advised her K-9 alerted, which provided us with probable cause search.
That's correct.
Okay. And then once in the vehicle, then marijuana was smelled.
Right. That's correct.
That's the proper chain of events, right?
That's correct.
You have reasonable suspicion, so you call the drug dog.
That's correct.
Talk to the DA's office, they said call the drug dog.
That's correct.
Drug dog came out, hit, gave you probable cause.
Correct.
Then you searched the vehicle.
That's correct.
I'll pass the witness.
So any other questions, Mr. Coleman, with regard to the probable cause to search and the suppression issue before? I think I need to rule on that before we go any further into any other testimony.
Not with regard to the probable cause and the search, Judge.
So, Mr. Gallimore, do you think it's necessary for me to hear from the witness with regard to, well, I guess maybe I could answer that myself. My thought is based on the evidence, even prior to the dog being called or getting there, that the officer, and I understand you used the word reasonable suspicion and he said yes, but it appears as though there was probable cause, in my opinion, earlier than the calling of the drug dog. And I think he testified to numerous reasons that would back that up. Number one, the arrestable offense that he intended to arrest the defendant for, which would obviously lead to the ability to inventory the car. The fact that he saw in plain view the money that was packaged or separated in a way that through his experience is something that is indicative of drug dealing, and that it was in doper increments, in his words. In addition, the knowledge that this officer had of the defendant himself personally from the prior offense that he's on probation for, and in that offense, which is a drug offense, that there was also indications of drug dealing at a house that they were surveilling, as well as a scale in addition to the drugs that would indicate drug dealing and not just personal use. And he also, well, okay, I think that's it with regard to the probable cause for the search. And so at this time, I'm going to...
Judge, may I argue?
Yeah, sure.
As it relates to whether there was probable cause at the time, the court stated that that he agreed with the word that I used. Number one, he did point out that in his report, it wasn't until, well, it was at the time that the canine handler alerted to him that the canine hid that he believed he had probable cause. That's what he put in his report. But it was is also his word in his report that he believed the description given as far as the previous offense and the doper money that he saw. Shoot. Oh, it was when Green asked the officer why he was going to search the vehicle. Is the officer, and I don't know if this was actually said specifically, but the officer stated, and it's going to be on the video, that they had reasonable suspicion that narcotics were in the vehicle. So it seems to me that the testimony today has, and that was something else that's going to be developed when we got past this point, but was that the version is being given in a way to say, hey, we were going to find it anyway. But when you look at the officer's perspective at the time, he believed he had reasonable suspicion. Those were his words that he used in his report. He also called the district attorney's office for advice on what to do. And their advice was not to search the vehicle, not that he had already had probable cause, but that he needed to have a drug dog. And then his words that were when the drug dog hit, he then had probable cause to search the vehicle. So the police and the district attorney's office at the time did not believe there was sufficient evidence to determine there was probable cause to search the vehicle at that time. And I tend to agree with them, to be honest with you. And that's the reason why we were having this hearing.
Mr. Coleman.
Judge, I think I agree with the court's line of reasoning and thought process as you laid it out before. I have nothing to add, Judge.
Well, I mean, is there any issue? I guess we can have Officer Lopez step down, get the other officer on. I can hear further evidence with regard to the canine. I don't think in my opinion, I don't believe it's 100% indicative of my, where I'm headed potentially, but it might give me at least more information. So let's do that. If you don't mind, sir, if you'll step down, just stay handy. We'll get you right back in, and then let's get the next witness.
Take about Tiffany Williams, Judge.
Good morning, ma'am. Morning. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Have a seat, please. You may proceed.
Thank you, Your Honor. Would you please? Sorry, I'm trying to get this in my pocket. It's not all right. Please state your full name for the court reporter.
Tiffany Williams.
And Officer Williams, how are you employed?
I'm employed with Arthur PD as a patrol officer.
Okay, and I'm going to ask you to speak up a little louder. The court hears everything you have to say. Are you a certified peace officer?
Yes.
In addition to being a certified peace officer, are you a certified canine handler?
Yes.
Were you certified as a canine handler back on March the 3rd of 2025?
Yes.
And were you working that day with your canine named Athena?
Yes.
Is Athena certified as a canine Help me with the terminology. Certified.
She's certified through NNDDA, which is a nationally recognized certification for narcotics.
And was she so certified back on March the 3rd of 2025?
Yes.
And were the two of you called out to the 3600 block of Gulfway in Port Arthur, Texas, in Jefferson County that day?
Yes.
And once you arrived, Officer Lopez, the Sonia, they were on the scene with a silver Volkswagen that they conducted a traffic stop on, correct?
Yes.
And they had a suspect who was identified as the driver who was standing outside of that vehicle. Did you see him in the courtroom today?
Yes, he's wearing a black hoodie.
And do you know that his name that he was ultimately identified as?
Ronnie Green. Sorry. Yeah, Ronnie Green.
Very good. I asked Your Honor, the record reflect the witnesses identified the defendant.
The record will so reflect.
And the process for running Athena on a vehicle or doing a free air sniff, very briefly, could you explain that for the court?
Normally the pattern I use is once I get her out, I let her take a break in a grassy area. If there's one close by, I bring her to the front driver corner of the vehicle. I give her a sit command, and once she sits, I give her a check command. We work normally in a counterclockwise pattern around the vehicle, and we conduct 2 passes if necessary. In this case, she didn't need the 2 passes, but that's typically the pattern that we go with.
And is there any reason you followed that process in this instance, correct?
Yes, we started that process.
You started that process.
Yes.
And at some point, did Athena alert on that silver Volkswagen?
Yes.
And in the process in the process of alerting on that silver vehicle, well, tell the court what you recognize in the way of an alert. How do you determine if Athena alerts on a vehicle?
It's a change of breathing and a change of body posture.
And you observed that with Athena in this case, right?
Yes.
What kind of substance or substances is or was Athena trained to alert on?
It's marijuana and THC products, methamphetamines, crack, cocaine, heroin, including black tar and powder heroin.
And have you run Athena on a vehicle or vehicles on a few or on many occasions?
Many.
And have you found Athena to be reliable?
Yes.
In fact, have you found contraband in instances where she has alerted on few or on many occasions?
On many.
And in this instance, she alerted on that silver Volkswagen, correct?
Yes.
Now, let's be clear about something for the court. When she alerted, the driver's side window was down, correct?
Correct.
And it would appear that Athena, when she alerted, stuck her nose inside of that driver's side window at some point, correct?
Yes. What she started showing the signs, and then she went up trying to get closer to the source.
And you understand that and you and I have had this conversation, you understand that there is an argument, at least, that by sticking her nose into that vehicle, the argument could be made that that was an improper intrusion into that vehicle and could arguably invalidate the search, correct?
Yes.
Okay. But nevertheless, she did alert, correct?
Correct.
And once back at the
Let me
PD,
make sure. I just want to make sure. Did she show signs before she had her nose in the vehicle or after?
Yes, now, so she did both. Whenever you can tell by the way her body is, she'll stiffen her tail and curl it. And she showed the change of breathing, went to the driver side and then went up after. And then she stiffened her body while she was postured on the car.
and once back at the PD, what, if anything, was done or conducted?
I followed Officer Lopez and Officer Villasana to the station after the vehicle was picked up, and they set out 5 bags. One contained the money that was inside the vehicle, and the other 4 were blank. I did not know which one the money was in. They just had them out ready for me to go when I got there. And I again ran Athena on those money bags, and she showed a response to one of the bags, which I later learned contained the money.
You were equipped with a body-worn camera that day?
Yes.
That body-worn camera was properly operating as far as you know?
Yes.
You as the operator certainly capable of properly operating it?
Yes.
This interaction, the dog alert on that silver Volkswagen was captured on your body-worn camera?
Yes.
May I approach the witness, Judge?
You may.
And I am going to show you what I am marking as State's Exhibit number 1. And I'm going to ask you first to identify this device for the record. What is this that I'm marking? What kind of a device is this?
It's a flash drive.
And the flash drive, you recognize it how?
Yes, I reviewed it and it has my initials and today's date on them.
And is this the body worn camera that you just testified about containing the interaction with the vehicle that
Yes.
Athena alerted on?
Yes,
True and fair, accurate copy with no alterations or deletions as far as you know?
correct.
Back was the last time you watched it?
A little while ago,
Just before testifying?
just before testifying.
Your State officer states, one, been previously provided to the defense counsel in discovery. No objection.
States one's and admitted.
Commissioner Post, Judge.
Yes, sir.
Seats. Check. Check. Back. Check. Check. Cute. Check. Check. Hey, you're good. Hey, you're good. Girl, here. Here. Hey, come on.
Judge, for the record, that was about in 11 seconds to 2 minutes and 20 seconds for the record that the state's published. That's all I wish to publish it.
I'll leave it up there though.
Okay.
Does the other officer's body cam?
Street, the front dash camera shows a better view.
Okay,
It captures.
I'm going to want to see that.
Now, I'd have to find his body cam. I mean, his dash cam. I've got his body camera ready and queued up, but I'd have to find his dash cam.
Does the body cam show it?
I think it does.
If he's,
Yeah, I think the problem is, I think the front dash shows the entire thing without moving around and everything. Like the body cam, the problem is always it's constantly moving away from the
but if
action.
he's sitting, let's get him back so I can take a look at that. And then if we need to get more, we can come back either later this afternoon or continue the hearing to the appropriate time when we can get that. So with regard to
That's it. I have
this part of it.
That's all I have for her, Judge.
Okay, Mr. Galmore.
Now, I'm going to ask as many questions as I can, and I may have to follow up with an additional question or two once we've seen the other videos, if necessary.
Okay.
I'm sorry, what was your name again?
Tiffany Williams.
Officer Williams.
Yes, sir.
Where was this dog certified? You said NDAA?
NDDA, we go through one of their guys in Baytown. He has I can't remember the address is, but the certifier has a building they use in Baytown.
Okay. Do you know where the dog was actually trained though? Like originally?
Through Jefferson County.
Like they took the dog as a puppy and taught it how to be a drug dog?
I got her as a puppy and we did all the training here with a certified trainer.
Okay. Okay, who was the certified trainer?
Bill Crane.
Who was that?
He's a Jefferson County deputy.
Okay. And do y'all have like a book you use to train these dogs?
He does all his training stuff that he went through to a school with, and I go I think I went through a basic school with them, if I remember right, and then I train almost weekly with them as well.
Okay, let me ask you this. Do you have a book on how to train a canine, drug dog canine?
No.
No. So you relied on the training from Mr. Green.
Crane.
Crane.
Yeah,
Bill Crane.
Yeah, Bill Crane.
We're on here on Mr. Green's case. Okay, so Bill Crane trained the dog. You don't know exactly how Bill Crane trained the dog.
I was there with them for everything.
Okay.
So, yes.
Did you ever see Bill Crane refer to a book on how to train the dog?
Not during our trainings, but I know that
Today's hearing demonstrates why suppression proceedings often determine the direction of a criminal case long before a jury is ever selected. Rather than focusing solely on the evidence recovered during the investigation, Judge Raquel West carefully examined whether every investigative step complied with constitutional requirements. The court reviewed the officer's observations, the timeline leading to the deployment of the narcotics detection dog, the legal significance of reasonable suspicion and probable cause, and the procedures followed before the vehicle search was conducted. Throughout the hearing, Judge Raquel West emphasized that the admissibility of evidence depends not only on what officers ultimately discover, but also on whether the search itself satisfies the legal standards required by the Constitution. Before reaching a final decision, the court indicated that additional evidence, including further video review, may be necessary to fully evaluate the suppression issues presented. This hearing serves as a reminder that suppression motions play a critical role in protecting constitutional rights while ensuring that criminal prosecutions proceed within the limits established by law.